All righty, getting going here. Good afternoon, everybody. Thank you so much for coming to this webinar entitled Religious Charter Schools Declared Unconstitutional, a webinar on the Oklahoma Supreme Court's recent ruling. My name is Bob Kim. I'm Executive Director of Education Law Center. For more information about ELC, we can drop a link in the chat function here, the chat screen, as well as information about our other participating and sponsoring organizations. If we have those, we can also drop those in the chat. I would like to start off by thanking our co-sponsors for this event. In addition to our own ELC, I want to thank the Americans United for Separation of Church and State, the American Civil Liberties Union, the Freedom from Religion Foundation, these are all organizations that represent plaintiffs as co-counsel in a separate lawsuit challenging the religious charter school in the case OKPLAC versus State Virtual Charter School Board. I also want to thank the National Education Association, the American Federation of Teachers, and all of our valued Oklahoma-based organizations, OKPLAC, Good Faith Media, Oklahoma Rural Schools Coalition, Oklahoma Education Needs and Donations, Oklahoma Appleseed, the Congregational B'nai Emunah, Emmanuel Synagogue, Interfaith Alliance of Oklahoma, and Oklahoma Faith Network. Also, thank you to ELC staff for organizing and setting up this webinar. Jessica Levin, Wendy Lecker, Sharon Krengle, Nicole Shulo, and Caitlin Comisanias. So today, without further ado, we are discussing the Oklahoma Supreme Court's recent decision in the case Drummond versus Oklahoma Statewide Virtual Charter School Board, which declared on June 25th that a charter contract establishing a religious charter school between the entities governed by the state of Oklahoma and the Catholic Church, the court held that that contract was unconstitutional and ordered the Oklahoma Charter School Board to rescind that contract. Just as a brief recap on that case, and I know the panelists will discuss it in far greater depth, the case was brought by Oklahoma Attorney General Gentner Drummond against the defendants, Oklahoma Statewide Virtual Charter School Board and the board's individual members. There was also the intervener defendant, the St. Isidore Catholic Virtual School. And the case really sought, and the Attorney General's office sought to bring this case directly to the Oklahoma Supreme Court to seek an order directing the Charter School Board to rescind the contract that we just spoke about with the St. Isidore Catholic Virtual School, and to declare that that contract had violated both state and federal law. The decision, which was handed down last month, the court declared that the contract with the St. Isidore Catholic Virtual School violated two provisions of the Oklahoma Constitution governing or prohibiting the use of public funds for the benefit of a religious institution and mandating that public schools must be free from sectarian control. The court also held that the contract violated the Charter School Act of Oklahoma, which mandates that charters as public schools must be free from sectarian control. Furthermore, the decision covered the fact that the contract also violated the federal establishment clause of the U.S. Constitution, which, as we know, prohibits excessive government entanglement with religion. The court specifically noted that because St. Isidore, in seeking to create a public school and acting as one, is a governmental entity. Because it's a governmental entity, in this context, it cannot ignore the mandates of the Establishment Clause. The court also did find that as a public charter school, St. Isidore Virtual School is a government entity and a state actor. And finally, in that case, the court found that the Free Exercise Clause of the U.S. Constitution is not implicated because it does not apply to governmental action. And as I just mentioned, St. Isidore, in the court's view, is a state-created school, or would be one, that does not exist independently of the state. The brief status here in this case is that St. Isidore has since moved in the Oklahoma Supreme Court for a stay of that decision. And the Oklahoma Supreme Court has not yet decided on this motion unless something happened in the last couple hours that I'm not aware of. And also relevant to the status here is that 2 days ago on July 30th, the defendants voted to file a petition in the United States Supreme Court challenging the Oklahoma Supreme Court decision. I'd like to also just briefly mention the second case that is ongoing related to these issues, OKPLAC versus the statewide virtual charter school board. The parties in that case, the plaintiffs, involve numerous Oklahoma faith leaders, public education advocates, including our lead named plaintiff, Oklahoma Parent Legislative Action Committee, and public school parents. The plaintiffs in that separate case are represented by Americans United, ACLU, ELC, Freedom from Religion Foundation, Odeman Sparks, and Douglas Mann. The defendants are many of the same ones that we mentioned in the Oklahoma Attorney General's case, in addition to including the state itself as responsible for the developments in this case. I won't go over the claims in depth, but I'll note that separate case only involves state law claims involving the Oklahoma Constitution, statutes, and regulations, and that case is currently stayed in light of the Oklahoma Supreme Court's decision in the Drummond case. And so that currently case is stayed upon a stipulation by all parties. As part of this stipulation, the Catholic school, virtual school, has agreed not to operate or accept any funding for the charter school for this upcoming 24-25 school year. So, you know, I'd just like to say in conclusion that, and as we start off here, that these cases raise numerous and profound issues impacting law, policy, education, and democracy writ large. That the issues really involve the redefining of public education, if you will, or the potential redefining of publication. It implicates limitations, or what should be the limitations, on taxpayer-funded religion. It involves discrimination against students and school staff in our public education system, the relationship between state and federal laws, evolving First Amendment jurisprudence, and really the nature and future of charter schools, just to name a few light topics. So there's a lot going on in these cases. So with that, I would like to turn to the meat of this webinar. We'll hear from our speakers, whose brief bios we will drop in the chat if we have not already done so. And then during the panel, for all of you in the audience and listening here today, we invite you to drop a question for our panelists, not in the chat function itself, but in that Q&A tab at the bottom of your screen. Please place any questions that come up for you during the panel in that Q&A screen, and we'll field those questions at the conclusion or toward the tail end of this webinar. So without further ado, the panelists and speakers we have before us here are Misty Bradley, Chair of the Oklahoma Parent Legislative Action Committee, or OKPLAC. I hope I'm saying that acronym correctly. Sarah Taitz, an attorney with the Americans United for Separation of Church and State. Welcome, Sarah. Renita Thukral, an attorney with the National Alliance for Public Schools. Hello, Renita. And Kevin Welner, a professor of education at the University of Colorado-Boulder and director of the National Education Policy Center. Hi, Kevin. So, Kevin, I would like to start with you just to get us going here. Give us your overview of the importance of these Oklahoma cases, in particular the one that has been recently decided by the Oklahoma Supreme Court. What's the importance of these cases? What might happen next in the cases, and what are your concerns here? And why should we, as members of the public and advocates and organizations around the country, be following these developments closely?
Thanks, Bob, and welcome everyone. Let me answer that question by taking a quick step back. I promise not to speak too long, but I want to take a quick step back and speak about the legal cases underlying that we're going to be talking about today. Well, actually, let me first by start by describing charter schools, right? Charter schools are statutorily designated as public schools in every state that has a charter school. Those same statutes have charters operating within the public school system. They're also tuition free, they're funded directly by the government, which I think is particularly important to note here. And they have other attributes that make them what courts call state actors. But they are privately operated, and that's the hook that St. Isidore and its allies want to hang their legal hat on. So these allies are attempting to expand upon a series of 3 US Supreme Court cases that started in 2017. Last one was in 2022 with a case called Carson versus Macon. That case involved a town tuitioning law in Maine that helped pay the private school tuition of some students who live in sparsely populated rural areas. And while participating private schools under that plan could be run by a religious organization, the education provided was required to be religiously neutral. That is, the Maine law required the school to have allowed the school to have a religious status, but the public money could not be put to a religious use. And then when it got up to the Supreme Court, the majority opinion in Carson rejected that distinction between status and use, meaning that the state couldn't prohibit religious uses of taxpayer funding in these private religious schools. Note here something that I think we'll be returning to repeatedly today. Carson involved public funding for schools that were unquestionably private. And that element was found to be crucially important by the majority in the Oklahoma Supreme Court case brought by the Attorney General that we're discussing today. So as Bob mentioned, the court stressed that St. Isidore is a state-created school that does not exist independently of the state, which sets it apart from the main private schools at issue in Carson. But, and this is the last bit of legal background that I'll mention, the US Supreme Court has been on quite a tear recently, and one of the most active areas has involved building up the free exercise clause as a type of anti-discrimination clause on steroids, among other things, protecting believers against denial of equal treatment in the distribution of government benefits. And it's in that context that we can understand the free exercise argument made by St. Isidore and its supporters, which hinges on a court focusing on the alleged unfair treatment of the private religious organizations running the school, rather than focusing on the question of the publicness of the charter school itself. So if the court went along with that framing, then it might be able to shoehorn the charter school situation to fit within the Carson precedent. And to understand what that looks like, we just have to look at the dissenting opinion in Oklahoma, which laid out the issues like, I'll quote 2 sentences. Quote, regardless of how the state chooses to label charter schools, the Charter School Act is clearly an invitation for private entities to contract to provide educational choices. The state is not required to partner with private entities to provide common education, but if it does, it cannot close the door to an otherwise qualified entity simply because it is sectarian. That's the end of the quote. Okay, so Bob, you asked me about the importance of this litigation, and I've been warning in particular against what I call the outsourcing of discrimination, whereby states can perpetrate discrimination against marginalized students and families by outsourcing that discrimination to private religious actors. So to understand that, imagine if the US Supreme Court takes up this case and does decide to extend the Carson reasoning to encompass charter schools. Imagine also that the court holds in this case or later one that the free exercise clause protects against enforcement of civil rights or anti-discrimination laws when that discrimination is rooted in religious beliefs. The result could easily be to tie the hands of state governments and charter authorizers, forcing them to grant charters to religious institutions that will avowedly not just proselytize and teach a religious curriculum, but will also exclude or otherwise discriminate against students based on their gender or sexual orientation, as well as the religious faith of the students and their families, with the state unable to step in to stop that discrimination. So I think that's one major issue of importance. Bob, I'll stop there and let you go on.
Yeah, I mean, thank you, Kevin. You've raised so many important themes already in your few minutes. You know, the last point you're making is really underscoring the issues and implications of discrimination and proliferating, and how um, state governments could and schools and public schools could have their hands tied if with a future ruling that argues that free exercise rights would allow that discrimination to occur even in a public school setting. You also raised the main case, the Supreme Court case Carson versus Macon, which was the town tuitioning program, in which the Supreme Court said a couple of years ago that to the extent that that tuitioning benefit is provided to non-sectarian schools, that it has to be provided equitably to sectarian schools as well. You raised charter schools, and just that's really at the heart of this case, and the public versus private nature of charter schools as well. So those are really, I think, important themes that you've already teed up, and hopefully we can return to some of those. I'd like to turn now to Sarah to talk about the separate case that I started off mentioning, but provided far too little detail on. Sarah, how does, you're with Americans United for Separation of Church and State, a real lead organizer and galvanizer of that separate lawsuit. Tell us about how the current Oklahoma Supreme Court ruling relates to and affects that separate case that you, along with ELC and other co-counsel, have brought. And maybe if you could also, why did AU decide to get involved and lead that charge, and what's at stake in that case, along and its relationship to the recent decision in the Oklahoma Supreme Court?
Absolutely. So our lawsuit was filed on behalf of OKPLAC and a group of Oklahoma taxpayers, including faith leaders, public school parents, and public education advocates. And that lawsuit predated the Attorney General's lawsuit and raised some similar and some different issues. Both lawsuits argue that the Oklahoma Constitution and Oklahoma Charter Schools Act don't allow for the establishment of a religious public charter school. And as we've talked about already, that's the issue that the Oklahoma Supreme Court ruled on in the Attorney General's case. And that's the reason that San Isidore is not going to be operating this fall. Our lawsuit on behalf of OKPLAC and other taxpayers additionally challenged the religious charter schools' discriminatory policies, which is what Kevin was just getting at. These issues were not raised in the Attorney General's case and not discussed in the Supreme Court opinion. But what San Isidore, the religious charter school, said was that the school claimed to be exempt from following anti-discrimination laws and special education law because of its religious beliefs. And for one example of that, most, if not all, employees were going to be required to be Catholic, and they were required to comply with certain interpretation of Catholic morality, which means effectively that the school was not willing to employ LGBTQ people. Similarly, LGBTQ students were not going to be welcome at San Isidore. This view of, quote, sexual morality will be taught and imposed on students if this school is ever allowed to open. For example, the school's handbook says very clearly, it has kind of a whole page about how they plan to treat transgender students, and that, for example, they're not going to use names and pronouns that affirm their gender. And then the school also discriminates against students on the basis of religion. It wants to have a pervasive religious environment with one specific religion. It wants to teach that religion as objective truth. And the documents the school released even said that the curriculum includes teaching students that if they don't believe in God, they're going to hell. So that's not welcoming all students the way that public schools are supposed to. And then another piece of the case involves the disability law. St. Isidore claims that it would only provide accommodations to students with disabilities if those accommodations don't conflict with the school's religious beliefs. So instead of following the law, they want to pick and choose which accommodations their religion is morally comfortable with. So our plaintiffs wanted to bring this case, and our organizations wanted to represent them, both because of the egregious separation of church and state problem, and because they don't want to see their tax dollars funding a school that discriminates. So for us, the discrimination claims were an important part of what is so objectionable about this particular school. And we wanted to make sure to highlight that in our lawsuit. This discrimination really goes against the heart of what public schools are supposed to do. And it's illegal in multiple respects. So in our case, the district court did recognize that we had adequately alleged those claims. It refused the defendant's motion to dismiss. So it didn't rule on those claims on the merits, but it did rule that our plaintiffs, as Oklahoma taxpayers, have a right to challenge the school on those grounds. So the Supreme Court, turning back to the Oklahoma Supreme Court decision, that decision did not give us a resolution on those important discrimination questions, but it did make a very powerful ruling on the establishment of a religious charter school and how much that goes against Oklahoma law. And it gave us the concrete outcome that we wanted and our plaintiffs wanted, which is that this school will not be opening and operating, at least not this year. So the OKPLAC lawsuit is now on pause. We entered an agreement with the defendants to stay the proceedings at least until February 2025. We actually had been preparing to go forward with a hearing on a motion for a temporary injunction just last month, but we didn't have to go through with it because of the Supreme Court opinion that gave us the exact relief that we wanted. As has already been mentioned, the board is going to try to take this case to the U.S. Supreme Court. And we're certainly hoping the U.S. Supreme Court will decline to take up the case. The board's going to petition for review, but that doesn't mean the court needs to hear the case. The Supreme Court only reviews a small handful of the many, many petitions it receives, and this just isn't a good candidate for Supreme Court review. Typically, the Supreme Court doesn't take cases of first impression. And here, the Oklahoma Supreme Court is the only court that's ever ruled on the legality of a religious public charter school. So typically the Supreme Court wants to take cases where multiple courts have weighed in, have given their analyses, and those courts have adopted conflicting rules such that the Supreme Court needs to weigh in as a supervisory court. We don't have that situation here. So it really wouldn't make sense for the Supreme Court to take this case up. And additionally, the Oklahoma Supreme Court's opinion is such a straightforward application of well-established law. The Oklahoma law says that public schools have to be non-sectarian. That's what the Oklahoma Supreme Court said. And there's really no reason for the U.S. Supreme Court to intervene with that. In the event that the Supreme Court does go ahead and take up the case, they should affirm what the Oklahoma Supreme Court did. As already has been mentioned, we know that this particular Supreme Court has expressed some unusual interpretations of what religious liberty means and requires. So we acknowledge that there's some risk going up with this case going up to the Supreme Court. But even this court that tends to be sympathetic to these so-called religious liberty claims that are coming from far-right groups that want to discriminate, this court really should still draw the line here. This is a religious public school. That should be a step too far, even for this court. So we're hopeful the U.S. Supreme Court is going to make the right call, which means that our case will be over. We'll have the outcome we want. But in the event the U.S. Supreme Court reverses the Oklahoma Supreme Court, we're prepared to move forward with our discrimination claims. Those discrimination claims are separate and apart from the question of whether a charter school can be religious. So even if the Supreme Court adopts this absurd idea that a public charter school can be religious, we're still going to argue that they need to be open and accepting to all students. And for those independent reasons, St. Isidore should be barred from operating.
Thank you, Sarah. Thank you, Sarah. That was really insightful as to what was happening in the separate case that you and others have brought in Oklahoma trial court, and the issues of discrimination that you specifically highlighted involving multiple student groups and of students of different categories, and potential civil rights violations and discrimination that would or could be experienced by those students. And then also really appreciated your comments about the prospects for review by this United States Supreme Court of the Oklahoma Supreme Court's decision, and why you think that may not be likely, or perhaps even ought not be likely. So thank you so much, Sarah. We can hopefully return for more in-depth commentary from you. I would like to now turn to Misty. You are not only a parent, but chair of the Oklahoma Parent Legislative Action Committee, the lead plaintiff of the case that Sarah was just talking about. So just I wanted to ask you, why did you and OKPLAC decide to join that case? And in terms of the separate case, the recent Oklahoma Supreme Court decision, how has that been received by not only by you, but other stakeholders in and out of Oklahoma? What are you hearing?
So to answer the first part of your question, thank you, Bob, is we actually knew this was coming at us. We've been feeling this, extreme kind of radicalization of, coming at us for quite some time. And when there started to be talk about St. Isidore, we really were searching for someone to help us take up this cause, because we've been parents that have been fighting for public education, and we know the ramifications that this has for our entire state and for the nation if this is able to go forward. And so it was something that we felt like was a fight that came to us, and that we needed help in being able to, we're just a grassroots group of parents. I mean, we're all volunteers. And so it's meant so much to us that we've had people like Americans United and all of you to be there with us to fight this right here at Oklahoma, even though we know it has such repercussions beyond here. And then let me say, we were very happy with the decision, but we weren't surprised, honestly, because Oklahoma's Supreme Court knows the law and they are upholding it. So there, it would have been shocking if it would have been any other decision. OKPLAC and other groups in Oklahoma and beyond, because let's face it, lots of eyes are on us, and we have people who are, standing in arm with us across the country. We're still guarded, and we're concerned because it seems like this, radical agenda is well-funded, and it's got no regard for our law, because it's very clear what our law is, and the high ideal of religious liberty in our country. So it's pretty evident by their extreme efforts to undermine Oklahoma's Constitution and some of the things that have went on inside of our state to stack boards and even trade out board members on the night before important votes that are quite honestly what we've been told illegal. And then just the continuous ushering in of regressive policies and initiatives that pave the way for, initiatives like Project 25 and 2025. And we know that Oklahoma's ground zero for that. And we've been a test site for these kinds of policies. And then you layer that on top with the divisive and heinous rhetoric that we are subjected to constantly. And it was absolutely something that we could not, sit down and take. And we have legislators who tell us constantly that they don't agree with Ryan Walters or him and his side's, efforts being made to subvert religious liberty, especially in education. But they have continued to refuse to take action against him. And quite honestly, right now, legally, they are the only ones who have the ability to stop that. And so, you have this kind of extreme radical thing that's coming at us. And then, you also have this very personal feeling of, you know, as for religious indoctrination being deeply tangled up with education, it wasn't so long ago in our state and others that there were people groups that experienced deep trauma and abuse and even deaths from a deadly mix of, you know, religious education and religion and education. I'm a Native American. I am a member of the Cherokee Nation, and it vexes me that we would even entertain publicly funding religious schools, especially religions that have such a dark, sordid past with this kind of education. And so I do believe there's legitimate cause for fear and for, you know, the collective to rise up against any movement of extremism that would return us to those kind of environments. And so I think these kinds of efforts that we're putting together are so important. And, you know, quite honestly, we've asked around, we have not seen any evidence of massive groups or parental groups asking for public religious schools. It seems to be driven by extremists, by think tanks, and a religious fervor by certain, you know, churches to evangelize. And we firmly believe that religious freedom means that no taxpayer should be forced to pay for the advancement of a religion or a sect, especially one that they don't practice. And the truth is that if Catholics or any church wants to open a virtual school, there is no law that prohibits them from doing that. There is no law that does that, but the law does prohibit them from doing so with public taxpayer funds. And so that's why we jumped into this fight. And that is something that we are passionate about, because we believe that all children should be able to go to school in a place that they are safe and that they are welcomed and they can learn free from religious indoctrination.
Thank you, Misty. That was really powerful, and I appreciated you sharing your background and how that informs, you know, your views on what is happening in this case, and also the fears that you mentioned, and the desire for safe and welcoming schools, and then the perspective of how you and others have received this recent decision, and I guess hopefully we can return back and have some discussion on what might advocates do in light of that decision further to educate the public on the important issues and concerns that you raised. So thank
Absolutely.
you. So Renita, if I could turn to you, you are an attorney with the National Alliance for Public Charter Schools. This case involves a brand of charter schools, virtual charter schools, and so it's really in your wheelhouse. Can you talk to us about these legal developments and their potential impact on the charter sector? I'm curious how the National Alliance for Public Charter Schools views the issues in this litigation and what the reactions might be in both the charter school space and sort of this burgeoning virtual charter school space. What are you hearing about that from within the charter community writ large?
Thank you, Bob. I'm honored to be part of the panel, and I have the unenviable position of being the last to speak. So I have to find something valuable and new to say, but I wanted to begin by saying I agree with what everyone else has already said. And there are a couple of key things that I just wanted to add as we lay the foundation to answer your question. I'm also coming to you guys from San Francisco, where it is solidly 55 degrees and feels like November, hence, you know, my turtleneck. So the one thing I wanted to begin with is actually something that Misty already just said, which is that the effort here in Oklahoma is not actually coming from the charter school community. It's not coming from existing charter schools. It's not coming from demand from charter school parents. It's not really even coming from demand from inside the public school community. This is something that is being, in my opinion, and I think it's fair to say, is being staged as a test case to get to the US Supreme Court. And the charter school mechanism is the vehicle by which the legal question is being presented to the courts. So I think it's important for all of us to acknowledge that this is not a part of the charter school community either in Oklahoma or anywhere in the country. And, you know, the second main point that I wanted to raise harkens a little bit back to something that Kevin mentioned, which is about the Oklahoma charter statute requiring that all charter schools in Oklahoma be non-sectarian. Well, that feature, that requirement exists in every single charter statute in the continental US. Every single charter statute in the entire continental US, and I'll explain why I say it that way, requires every charter school to be non-sectarian. So again, this is how every charter statute began and how the charter communities in every state has evolved, right? Non-sectarian from the beginning all the way through this point, including in Oklahoma. The reason I caveat that with continental US, and I saw Sarah smile, is because there was a recent effort in Guam to revisit this question about whether or not the non-sectarian requirement in the Guam charter statute was appropriate or not. And so there was some back and forth between the Attorney General in Guam, their legislative body, and ultimately that non-sectarian requirement was removed from the charter statute in Guam in order to allow, but if you look into the legislative history, in order to allow a parochial private school to convert into a charter school, which it did do, but then removed all of its religious curriculum. So you had a parochial private school become a non-sectarian charter school in Guam. So even in Guam, there are still no religious charter schools. So that's why when I mentioned earlier, the caveat on continental US is simply to acknowledge the Guam wrinkle, which is recent. And then the third thing I wanted to do is just to begin by applauding the Attorney General in Oklahoma for the steps taken to intervene in this case, to expedite the case to the Oklahoma Supreme Court. From the charter school perspective, that was incredible leadership and incredibly smart to get ahead in that way. And to bring a question of first impression postured like this so that we can get it resolved quickly and so that the school can't open sort of decisively for now. The National Alliance agrees wholeheartedly with the decision issued by the Oklahoma Supreme Court. We sort of couldn't have written it better. So not only did we appreciate the effort by the Attorney General stepping in, but the briefing and the oral argument, I thought, showed incredible leadership. And we felt like the Oklahoma Supreme Court decision really picked up on the key elements in the briefing and the oral argument, and then set up precedent that we were incredibly proud of. The National Alliance filed an amicus brief in support of the Attorney General's position with the Oklahoma Supreme Court because the merits briefing spoke a lot about charter schools as state actors, in addition to all the Oklahoma statutory and constitutional arguments. They also talked about charter schools as state actors. So our amicus brief focused on the governmental nature of the authorizer itself, and that the authorizer itself, as a governmental body, could not contract for any kind to create any kind of religious institution, that simply explicitly violates the Establishment Clause, right? An authorizer cannot establish, a governmental body, the authorizer cannot establish a religious institution, which is what the school would have been. So we're very pleased to see kind of what the courts have done so far. And I to your question about how is the charter school community thinking about this, one of the things that I think is important to note, and I'm conscious of the time, so I won't go on and on and on, but I wanted to just acknowledge that the charter community has been contending with this question about whether or not charter schools are state actors for purposes of students' rights under the US Constitution for nearly a decade. This is not a new question for us. It has come up in other contexts. And we feel very strongly, and we've taken this position in legal papers filed across the country, that charter schools are state actors for purposes of students' rights under the US Constitution. And we use the state actor tests that Kevin alluded to as examples of, or as the way to show and illustrate the statutory constructs in every state yield that conclusion. So, just a quick summary of how we get there, right? Early days in the charter community, there were a handful of federal cases that questioned the state actor status, and it was very interesting. Those federal court decisions all very, very quickly do some quick analysis of charter schools are public schools set up, as Kevin said, part of the public school system under the Education Clause of the state constitution. Therefore, of course, they're subject to the US Constitution. Therefore, whatever the therefore is. So in the early years, that was the scope of analysis. It was pretty brief. The first time you really start to see a deep dive discussion is out of a case in North Carolina called Peltier. It's a case brought by the ACLU. Huge kudos to the ACLU for bringing that case and seeing it all the way through 2023. I think it started in 2016, ended in 2023 when the US Supreme Court denied cert. That was a case in which the question was raised about whether or not the North Carolina charter school was a state actor for purposes of the Equal Protection Clause. And through many iterations, the trial court, there were several questions raised, but that's the one I'll focus on today. The trial court said yes, state actors for purposes of the Equal Protection Clause. In a 2-to-1 decision, the Fourth Circuit reversed and said nope. And the reasoning there is very similar to what Kevin read in the dissent of the Oklahoma, right? There's a thread there that you see anytime a court decides a charter school is not a state actor. So then the ACLU sought en banc review. The National Alliance filed a brief in support of the ACLU's request for en banc review. The court agreed. The en banc court ruled 9-6 that the North Carolina charter school was a state actor for purposes of the Equal Protection Clause. And then the US Supreme Court declined cert. So that case gave the National Alliance and the entire charter school community many, many, many years to evaluate, discuss, and agree that charter schools are state actors for these purposes of students' rights under the US Constitution. So then when the Oklahoma case comes up, we've done our work. We understand from a legal perspective, and in addition to the students' rights perspective, that we agree in the way that Sarah laid those out, politics, policy, right? So all of those are different layers to this question, but from a legal perspective, we had answered it from our definitively on the state actor side. I wanted to also flag the decision that Kevin put into the chat. This Willard case is also very important. It's now up on appeal in the Ninth Circuit. And that's a case in which 2 charter schools in California were asked to provide religious curriculum by parents. The schools said, no, we can't because we are public schools and bound to be non-sectarian. They got sued. And in a very interesting decision from a George W. Bush appointee, that federal court, in a very decisive decision, said, plaintiffs, you're off base here. I'm going to dismiss your complaint with prejudice, right? That's, as we all know, an unheard of action or a very uncommon action by a federal court. And I think that decision, like Kevin says in the chat, nicely aligns with what the Oklahoma court does, and the reasonings adopted by both are convergent.
Great. Thank you, Renita. You've advanced the ball so much in this discussion already, but I particularly appreciate your encapsulating that this development in Oklahoma is not something that's born out of charter schools or the community at large. You really clarified the charter school sector and governing bodies, growing consensus around the question of charter schools being public and state actors. And you also clarified in a really insightful way that it's not just the schools themselves, but it's the authorizers themselves that are acting as part of state action and government entities as well as the schools themselves. So that and a number of other things and related cases. So I'm just very grateful to you for helping to clarify all of that. I guess I would like to also invite folks again, if you have a question, to put it in the chat. Or no, not in the chat, in the Q&A. I'm calling it the button. I see the button. I can pull up the button. I am technologically astute in ways that would surprise myself. So so please do that. One kind of aggregated question that seems to be coming out of the chat, and this also goes, I think, Misty and others, to advocacy and how we go on from here. But given that some state officials may not want to follow this recent Oklahoma Supreme Court decision, how can public education advocates have optimism and really engage in productive discourse with policymakers and other leaders in both in and outside of Oklahoma? So I don't know, starting with you, Misty, but talking, I invite anyone to respond to how we can use the opinion to galvanize public attention and commitment to this issue going
Yeah.
forward.
Thank you, Bob. I will say, and just to be completely transparent and honest here, morale is low because it has been such an onslaught, I think, over the last a few years. But we can see here with this decision that it is galvanizing in the sense that it's like, we know we are on the side of the law and that this has history in our state and it has meaning. It's, religious liberty is a high ideal of the American experiment. And so we have to cling to that, and we have to continue to, most of all, talk about the beauty of public education in the schools and what it does for students and how it creates a playing field that all are welcome to and all are able to succeed and use that as a launching pad, and that it is good for our society. And so we have to continue to tell those stories and to encourage each other and to love on our teachers and to love on our administrators who are in this fight every single day, and to work with our districts to be able to take the true concerns of what are facing our kids every day, true concerns, not the made up weird culture wars, but the true concerns to our legislators and say, this is what you need to focus on. And so we have to continue to educate each other and talk to each other and lean on our legislators to focus on the right things, focus on the things that are going to move us forward and not send us into a regressive past history.
Yeah, thank you. Here's another specific question. I don't know if Renita, you want to take this or others, but why do you think private schools such as St. Isidore are aiming to be charter schools when they could just as easily be a private school? They could maintain all of their autonomy and establish, maintain the sanctity and tenets of their religion in their practices, in their hiring, in their admissions. So why do this?
I mean, it's a great question, and obviously I would be speculating, right? I don't know for sure. I do know, or at least I had been told before the virtual charter school board approved the charter application submitted by St. Isidore, there were conversations with the Archdiocese in Tulsa and Oklahoma, encouraging or exploring the possibility of being a private school and receiving voucher funding, which is available in Oklahoma. And that could have been one way for them to do all the things that you identified. And obviously they chose to go this route. And, no one's told me what their reasoning is, but I imagine it's in part to set up the test case to bring to the courts. I imagine that animates part of the decision. But I would be remiss if I didn't also acknowledge that 200 plus families tried to enroll in that school had operations been allowed to, continue. And so I think St. Isidore would say that there is an interest in the public school community to have this option. And so, depending on whose perspective, you're inclined to believe, a combination of both. They either wanted to test it out or they also wanted to bring this possibility forward. Now, I would also just acknowledge that this is a virtual public charter school that has this religious component. And it did, at least in the conversations in front of the authorizer, seem to be trying to provide this educational option to rural families in Oklahoma. And maybe there isn't the possibility for a private school to be virtual. I really don't know whether or not there are private virtual schools in Oklahoma. And it sounded like they wanted to create a virtual option in order to provide this particular religious curriculum to rural families. So I don't obviously know the answer, but I imagine it could be explained in a variety of ways.
Yeah.
Bob, could I chime in just briefly on that question?
Absolutely.
I think understanding this litigation, which gets a little bit to the test case element of what Renita's talking about, but I think it goes beyond that. I think we have a larger push in the country to attack not just public education, but publicness in terms of all elements of education. So that would include district-run public schools, charter schools, and voucher plans. So if you think about, just using the last example, if you think about the way that private education is funded in places like the Netherlands or a lot of places in Western Europe, that basically the private churches and private organizations that run publicly funded schools are highly regulated. They are not what we think of in terms of vouchers in this country. They are private providers of public education, similar in some ways to what we saw in Maine with the Carson case. And that is anathema here, partly because of the free exercise clause, but also partly because of the nature of advocacy for school choice in the US.
Okay.
And if you think about even district-run public schools and catchment areas and excluding families from well-resourced, more elite schools, there are access questions there that are about publicness, right? Within school tracking raises questions about access and publicness. Certainly charter schools have had major issues around denying access and shaping who enrolls. And so how we structure all those different types of policies, intra-district and intra-district choice would be other examples. How we structure all of those different types of policies implicate issues of publicness. And I think it's that broader fight that's implicated here, that there are groups throughout this country, and those think tanks that Renita mentions are part of that, or I think it might have been Misty, that are pushing back on publicness in pretty much every element of education in the US.
Yeah, that's like super profound. And I know you've mentioned Europe and other parts of the world where there is a religious mixing and providing of education, but in exchange, they are heavily regulated and give up the religious part in the delivery of that public function. And Renita, you were kind of mentioning Guam and what happened with the charter progression in that territory as well. Sarah, I just wanted to return to you for a minute, and I don't know if you have a moment to elaborate on the discrimination principles that you started to speak about, and what was going on with what's really at stake in terms of kids' rights in different domains with this development. And are you worried about the specter of free exercise? And Kevin started to mention this as well about, there were two parts of the Oklahoma Supreme Court decision, one saying, no, free exercise is not involved. The dissent said, yes, the free exercise clause is in fact and would be violated by this decision, by the denial of that contract. What are your concerns around both discrimination in general as applied to different student groups and these developments, and how it might overshadow or minimize those discrimination concerns?
The far right is definitely trying to set up a conflict between the free exercise clause and anti-discrimination clause and anti-discrimination laws in general. And it's really unfortunate because that conflict does not need to exist. And that piece of the case is why I saw someone in the chat asked how the US Supreme Court can opine on this when it's about Oklahoma law. And it's because of this angle that the St. Isidore and the board say that they're protected by, that the school is protected by the federal free exercise clause. So there is an element of federal law at stake here, and that federal law would make Oklahoma's law unconstitutional. It would also make potentially many other anti-discrimination laws unconstitutional in certain applications. So that's a deeply concerning trend that's not just happening in schools, it's happening in a variety of contexts. And at Americans United, we kind of have a tagline about how religion and religious liberty should be a shield that protects people, not a sword to attack people. And that's kind of what you see when people use free exercise clause as an excuse to discriminate. Everyone is entitled to their religious beliefs. That doesn't mean they're entitled to discriminate against other people in education, employment, providing public services. And this conflict we can respect everyone's religious liberties and enforce anti-discrimination law, and this conflict just doesn't actually need to exist.
Thank you, Sarah. And I know as we already are at sort of the conclusion of the last few minutes for our webinar, I thought I would just do a quick fire go around and for the good of the order and ask each of you, what's one takeaway that you're holding on to from the Oklahoma Supreme Court decision, and what's one thing that we ought to focus on or do in the future to make sure that attention continues to grow on these developments and this litigation movement in these two cases. So, with that, whoever wants to go first, I would just do a quick fire here for all of us at the top of the hour here.
I can jump in. So one takeaway that I have from the decision is the way in which the courts, Oklahoma, the Peltier courts, and the Woolard case out of California, you're seeing all of these courts basically preserve status quo for the charter community and for students attending charter schools. That we believe that charter schools have always been state actors for these purposes. So kids have always had their constitutional rights when they attend public charter schools, and we're seeing the courts hold that line, which I'm very grateful for and happy to see. In terms of what to keep our eye on is the possibility that that line shifts, right? And that all the bad things that come with that, I couldn't agree more with both Kevin and Sarah and the ways they characterize the bad that could follow. And as we know, right, these are decisions that affect an entire state. If we're talking, the statutory framework in a state. So if St. Isidore, for instance, were to be construed to not be a state actor and therefore could be religious, right? That doesn't just mean only St. Isidore is not a state actor. It means all charter schools in Oklahoma are no longer state actors, and none of them would be subjected to the US Constitution. Now, I know some people would push back and say, these are very fact-specific things and you have to do so on and so forth. But, I don't know that is something that we should overlook as a very real danger about the way that constitutional protections for students' rights in all charter schools could be lost.
Yeah.
If the courts change the line here.
Yeah. Thank you, Renita. Who wants to go next? Just a few seconds each for each of us here.
For me, the takeaway is don't sleep on state courts. Civil rights activists and litigators really should be focusing on state courts as an avenue for achieving civil rights victories. And even, you think of Oklahoma as a red state, but this court did absolutely the right thing.
Thank you, Sarah. Here on that message. Misty or Kevin?
Yeah, I would just say that to just keep pointing to our true north, which is our Constitution, and that our state Supreme Court knows our laws, and we just have to keep reminding people to keep the eye on the ball and the truth, because that's the thing that keeps getting thrown around here is so much confusion and so much misinformation and disinformation. And so it felt like a real win for the truth.
Thank you. Kevin, last word.
Yeah, I guess I'll return to the publicness issue and the larger battles. This is one of many battles in, I hate military metaphors, but here I go. One of many battles in the larger war over protecting public education and publicness in education, right? And I just think that we have to understand that it isn't just a legal struggle. It's a larger political struggle. It involves investing in and caring about public education.
Great. Oh my goodness. This has been amazing. You went above and beyond what was asked of you. I think it broadened our minds. So thank you to all four of our panelists for your comments and insights. Thank you to everyone for attending this session. It is recorded. I think we will make this available for the public. But I really do want to close by thanking everyone here and for just the ability to take a little bit of time here in the beginning of August over the summer to focus on issues and developments in education that are really critical to our future, you know, and to the development and history and future of public education, to the development of law, important constitutional principles, important civil rights principles. I think this is easily one of the top issues in education on all of those fronts of the last several years. So I think it was time well spent. I hope we all agree to spend a little time in conversation around these issues. So thank you, everyone, and have a great rest of your day.
Thank you.
Thank
Thanks, Bob.
you.
Thank you all.